Now we are going to move to our next keynoter. Jeff, if you'll come on up. I'm really pleased that the Honorable Jeff Rosen is here to deliver important remarks to us today. Actually, everyone, a lot of those here today, everyone in some way is honorable, but Jeff, I think, especially deserves that title. As most of you know, and as you can see from your brochure, Jeff is a former acting Attorney General of the United States and Deputy Attorney General of the United States in the Trump administration. Now, Jeff is a longtime friend of mine, so with his permission, I'm going to dispense with the honorable and refer to Jeff as a friend. Jeff is presently practicing law with Cravath, Swain, and Moore here in their Washington office. And again, I'm just going to name a few of Jeff's the highlights from his biography. But he in addition to the positions I've mentioned, Jeff has served as Deputy Secretary of the Department of Transportation and General Counsel of the Department of Transportation, and also General Counsel and a Senior Advisor at the White House Office of Management and Budget. So that's quite a distinguished list of offices, from the Department of Justice to OMB and DOT. Now, while I certainly didn't rise to anything close to those august offices that my friend Jeff Rosen did by any means, we do share the modest distinction of both having served as public members of the Administrative Conference of the United States and the American Bar Association's section of administrative law and regulatory practice. And Jeff is also a winner of the Administrative Law Section's prestigious Mary Lawton Award for his government service. You know, I think with having in mind the offices that he's served in when Jeff delivers his remarks today, and by the way, the title of his keynote is "The Pen and the Phone and the Regulatory Pendulum Problem." You'll see how grounded they are in part in his knowledge and expertise and experience gained in those offices. And then finally, I want to say this about Jeff. Jeff, as I mentioned, served in President Trump's administration as Deputy Attorney General, and then as Acting Attorney General in the last days of President Trump's administration. But one thing I'm confident of, and many of you already may know this, but I'm sure history will record that Jeffrey Rosen served with the utmost integrity at difficult times during the days that he was acting Attorney General, and served honorably. And I'm really proud that Jeffrey Rosen is a friend of mine, and I'll look forward to your remarks, Jeff.
All right, let me get that set up. And so let me start by just thanking you, Randy. Thank you and the Free State Foundation for having me here today, and thanks to all of you for being here. The subjects of my remarks, certainly as Randy alluded to, have been informed by my times in government service and other roles that Randy mentioned. But I am, just like former government officials used to say, speaking solely for myself. Now, as Randy alluded to and as the program reveals, the topic for me today is the pen and the phone and the regulatory pendulum problem. So some people are asking, what is that? So I'm going to start by explaining what those are, because perhaps for some people, those terms will have a back to the future quality from my using terminology from about 10 years ago. The pen and the phone is a phrase coined by President Obama, actually, at a time when he had been unsuccessful in obtaining legislation. And he announced, this was back in 2014, that if Congress wasn't agreeable to giving him what he was asking for, he would find ways to do it through executive action, with the pen being a metaphor for executive orders and other presidential directives, and the phone being his ability to call the people in the federal government who worked for him, doing regulations and other regulatory things such as guidance documents. So the pen and the phone is loosely a reference to executive orders and regulations. And that's how I'm going to use the term today. Now, the pendulum problem, the regulatory pendulum problem, is probably a less well-known term, and there are probably other synonyms for it. But what it refers to is the phenomenon of a president and the agencies putting out policy-oriented regulations that don't have the same kind of durability that legislation has, because they can be changed by a subsequent president. So one president puts in a regulation, subsequent president removes it. Third president puts it back in, or maybe puts it in a more aggressive form, and then down the road, another president of the opposite party comes in and again removes it. Regulations, it's always worth remembering, regulations are laws. So the regulatory pendulum is meant to describe when there's a legal requirement for some period of time, and then it's not a legal requirement anymore for a period of time, and then with another election, it's back to being the law, and it goes back and forth. So an example of this that I imagine folks in this room are familiar with is the net neutrality rule. 16 years of net neutrality discussion. So, but as I'm sure everybody here knows, the net neutrality rule was adopted by the FCC during the Obama years, was revoked by the FCC in the Trump years. It's been proposed for restoration by the Biden FCC last year. And if the FCC finalizes it, it wouldn't be that surprising to see a future FCC with a majority appointed by a different president take it back out. So that's the regulatory pendulum issue. And it's actually the core part of what I want to talk about today, in part because the regulatory pendulum over time has gained increasing amplitudes and increasing speed. And I'll address some of the difficulties that presents. But before I get there, I want to start with this. Under our Constitution, who's supposed to make the laws? Under Article 1 of the Constitution, that's the Congress. Quote, all legislative powers herein granted shall be vested in a Congress of the United States, close quote. And under the Constitution, the executive branch is supposed to implement what Congress has enacted and enforce the laws. As set out in Article 2 of the Constitution, the President, quote, shall take care that the laws be faithfully executed, close quote. Unfortunately, this is not quite how things work anymore, and it hasn't been the case for quite a while. For some time now, it's been the situation that the annual number of new regulations has substantially exceeded the number of laws passed by Congress. So if we just look at the most recent year, 2023, in that year, 236 significant final regulations were put into effect by agencies, 236. That compares to less than 40 laws enacted by Congress last year. That's almost 6 times as many laws by regulation as laws by Congress. And then if we look at the first 3 years of the current administration, counting both executive branch agencies and the so-called independent agencies, there's a record-setting pace so far of 826 significant final rules, which cost, by the agency's own estimates, $452 billion of costs so far. And in addition to that $452 billion, agencies have published another set of 365 proposed rules, which, if adopted, would add another $615 billion of new costs. Those are big ticket requirements, and that's the way laws are being made these days, with huge consequence, huge impact. I'm sure in various realms, we can all think of big dollar examples, depending on what areas people focus on, whether that's Treasury's beneficial ownership rule, the SEC's private advisor rule, the Labor Department's rule on tips, EPA's ozone and mercury rules, the Energy Department's energy conservation rules, HHS's minimum staffing rules for long-term care, and the FCC's recently adopted digital discrimination regulations. As to the number, the cost, and the impact of rules, that's a familiar topic, but that's what the pen and the phone is about. Now, by contrast, in a system where Congress used to make the laws, Congress has procedures that makes it harder to change them. They tend to have more durability and continuity. That's less and less true when the executive branch is making the laws. So the regulatory pendulum presents a different set of challenges that I'll elaborate on shortly, because this is the playing field I wanted to set out. And then I'm going to talk about this in three parts corresponding to the three branches of government and the three parts of the Constitution. So part one, executive branch. I'll start there, and for today's purposes, I'm including the independent agencies. Over time, the executive branch has become bigger and more powerful. It's not exactly a new observation, but it's a reality that has increased with time right up to the current day. And the ability to make new laws that are done unilaterally and without budget limits, that's a powerful tool. And there are obviously matters of concern from that. One of the concerns is the costs, which are an issue and have been an issue for some time, as I was alluding to a moment ago. But that's not the only aspect of the pen and the phone that pushes new outer boundaries. Another is the controversies over legal authority. And this has been going on for a while too, so I don't mean to focus solely on the current administration. I'm just describing a problem which over time has increased on an almost continuous basis right up to the present day. In the Trump years, some advocacy groups criticized immigration rules as being beyond statutory authority or as violating the Administrative Procedure Act, as the Supreme Court held with regard to the Department of Homeland Security's repeal of DACA rules, for example. In more recent years, there have been other rules that the Supreme Court has said exceeded the actual authority the agencies had. I'm thinking about the Center for Disease Control's rule preventing evictions of renters, the Department of Education's student loan cancellation rules, and the EPA's power plant rule. And there are many others that have generated legal controversy. And the reason I'm noting these is not to say who's right or wrong, or whether regulation is too much or too little, but to focus us on the consequences. The fact that it's the executive branch that's making laws and that the stakes have increased. They've increased because there are more consequential rules, there are more costly rules, there are more subject matters being addressed. All of these increase the tendency of presidents of both parties to use the pen and the phone. And that inclination does not appear likely to recede anytime soon. Now, a key aspect of the pen and the phone, as I've referenced, is that compared to laws made by Congress, laws made by agencies are much more subject to being reversed with a change in the presidency, and they're more easily and more readily able to be changed every time there's an election. And unlike Congress, the executive branch is an all-or-nothing proposition where only one party controls it at a given time, as compared to Congress, where there are representatives of at least two parties, and the minority side is not totally powerless. That brings me again to the regulatory pendulum. This is an area where in decades past there used to be some continuity and stability. And I want to share with you an illustration of what I'm talking about, starting by describing presidential executive orders. There are now, cumulatively, on the order of about 14,000 executive orders issued by 46 presidents, going all the way back to George Washington. The way these worked over quite a long period of time, until the last decade or two, was that there was a lot of stability in that presidents typically added new ones, but they didn't really subtract from the old ones. They sometimes modified them, they sometimes updated them, they supplemented them, they changed some terms, but by and large, the body of executive orders stayed fairly consistent. So if we look back to the first 6 months of each new administration during the last 25 years, that continuity has receded. I'll start at the end in the transfer from Clinton to Bush. In the first 6 months after President Bush took over from President Clinton, President Bush revoked 6 executive orders, 6. All but one dealt with labor union type issues, which is an area the two parties had had historically a long disagreement. Bush didn't change any of Clinton's executive orders that dealt with regulation policy, including the executive order that set up the OMB process for centralized review of agency regulations. That was left in place. So then President Obama came in after President Bush, and he revoked 8 executive orders. And he flipped the switch on the labor ones, but he also revoked one that Bush had done on the regulatory process, and also a pair about stem cells and terrorist interrogations. So the number increased just a little, the subject matters a little. Then President Trump came in. He issued numerous executive orders of his own, a large set, but he only revoked 6 of the executive orders from President Obama. He didn't revoke any of the Obama directives on the regulatory process, but he revoked a number of policy-related executive orders, particularly about climate change and energy development. So more subjects. Fast forward to 2021, when the current administration came in. In its first month, the current administration issued 40 executive orders or directives, which was many more than the 7 prior presidents. In its first 6 months, the current administration revoked 44 Trump executive orders, including all 6 of Trump's that dealt with the regulatory process, and a host of others dealing with energy development, infrastructure permitting, apprenticeships, TikTok, border security, refugee vetting, the financial system, and more. And again, you may agree or you may disagree with the specifics of any of those. But the point I'm getting at is the tendency to revoke predecessors' directives has gained both volume and speed as time has passed. And I think it's safe to predict that that trend is unlikely to recede when there's a party switch in the White House. With agency regulations, something similar has occurred over time as well, as there had been some continuity in the past. As presidents came in, they and their agency appointees tended to focus on the new things they wanted to do, on their own priorities. But that's when the pen and the phone and the pendulum began to intersect, because as the number, the cost, and the policy role of regulations increased substantially, they generated even more desire and more will to undo those actions of predecessor administrations. So the Obama administration had implemented some costly, some controversial rules. As examples, there were the EPA climate rules and the Labor Department's joint employer rule and its fiduciary rule. So the Trump administration came in and its agencies revoked some of those high visibility rules from the Obama administration. Not just those EPA and labor examples, but think about, as we've referenced, net neutrality mandates, the Education Department's Title IX college sexual misconduct regulations, EPA's rules about waters of the United States, and DOT's fuel economy requirements. Then the Biden administration came in and began to revoke rules that were promulgated in the Trump administration in even a more aggressive manner, trying to pull them out root and branch And in many cases, not just ending the Trump rules, but also swinging the pendulum back to those that had been put in the Obama era, or sometimes with more ambitious versions of requirements that had previously put in place in the Obama years. The Brookings Institute has a regulatory tracker, and if you look at it, it says that of the first 43 regulations or regulatory actions from the current administration, 25 of those 43 were rescissions, reversals, or delays of the prior administration's actions. And it's not hard now to think about rules that are just regularly going back and forth. The FCC's net neutrality rule being one, of course, but EPA's climate rules, labor's overtime rules, HHS's abortion-related rules, some immigration-related rules. There's a set of these, and others may join, such as the Council of Environmental Quality previously did revisions, which have now in part been revoked regarding the NEPA permitting process, and others. The recent revocations in the last 3 years have even extended to rules about the process. During the previous administration, numerous agencies had put in regulations, sometimes called the rule on rules. And those were requirements for due process and to set what procedures were needed to issue new rules, such as that the more consequential the rule was, the more procedural protections the public would be afforded. The current administration revoked those at roughly a dozen agencies. And again, you can agree or disagree with the specific actions and the specific rules. But the process of these revocations, it's both broadening and it's accelerating, and it's likely to continue to do so. That takes me to the Office of Management and Budget, of which I'm an alum, and specifically to the office called OIRA, which is the Centralized Regulatory Review Office. That had been a source of continuity for many years. Among other things, OIRA historically exercised self-oversight of executive branch agencies and self-discipline. So it was a long-term source of stability over a 40-year window, and perhaps something of a restraint on the pendulum effect at times. For most of the first 2 years of the current administration, there was not even a confirmed or even a nominated head of OIRA to oversee the regulatory process. Now there is, but the biggest thing that happened last year was another pendulum-type event, destabilizing the rules for cost-benefit analysis and other regulatory analysis that had been in place for more than 20 years. It's called Circular A4, and a number of controversial changes were made that appear to facilitate more regulation and higher regulatory costs that have now been put in place. So instead of continuity and stability, these changes almost ensure that in a future administration, Circular A4 will become a subject of the regulatory pendulum. Time will tell, but there is reason to be concerned whether all self-restraint by the executive branch will be essentially out the window in the future. No one can say with certainty, but it seems to me myopic to think that one administration can proceed with ambitious revocations and replacements, and that that's not going to reverberate with a pendulum that comes back the other way. This pendulum effect, you know, the genie's out of the bottle, and it ought to be common sense that it is easier to let genies out of the bottle than it is to get them back in. Does it matter if the executive branch over time chooses to exercise less self-restraint and the oscillation and the amplitude of the pendulum gets bigger? What are the consequences? So there are obviously reasons why administrations of both parties do this. And if some policies they regard as detrimental are replaced, even temporarily, maybe there are situations where that is helpful. But there are also difficulties. Those are first and foremost a problem for the regulated businesses. And not just businesses, but hospitals, schools, local governments, all regulated parties, because they experience regulatory whiplash. But sometimes the effects are not just limited to them. They can be a situation undesirable for our society and for the economy as a whole, because the swinging pendulum produces uncertainty, makes it difficult to plan, especially as to capital expenditures or other kinds of future-oriented expenditures, such as the training of employees. A second problem is related to the uncertainty, and that's waste and inefficiency. Consider the EPA mercury rule that went into effect in 2012. It was invalidated in 2015 in a case called Michigan versus EPA. But the money to comply had already been spent. So large amounts of money were spent, and then the rule was gone. The pendulum swings, so now here we are more than a decade later, or about a decade later, and EPA is trying again. A third problem, which is a societal and a policy problem, is that the pendulum effect can lead to ineffective policies, ineffective in both directions, especially if agency officials try to shoehorn new rules into old statutes that are poor fits. Sometimes revocations don't even restore the status quo, because there have been actions taken by the regulated parties as a result of regulations when they were in effect, even if they never go back into effect. On the other side of the ledger, if it's understood that rules may be revoked, there's the possibility there will be less compliance, or at least more waiting to see what happens. A fourth potentially bad consequence is that the pendulum can induce some regulated entities to adopt a strategy in which, because they don't know what the rules are going to be, they don't know what the law is going to be anymore, they become instead what economists call rent-seeking entities, seeking subsidies and governmental support. We'll play by whatever rules you want, just fund us. If that occurs, it hurts all of us. And then fifth, there is a harm that's less about the participants and more about our political system, which is that when the White House becomes a winner-take-all way to make laws, more like a parliamentary system, so that if you get it, you get to do what you want with no role for the minority side, you create much more pressure for gaining control of the White House. That's certainly something we observe, and maybe it helps explain some really disturbing things. Like last October, there was a University of Virginia poll that reported that 38% of Trump supporters and 41% of Biden supporters said it is acceptable to use violence to stop the other side from achieving their policy goals. That's deeply troubling. The underlying problem is that in a well-functioning system, many of these policy matters that swing back and forth, they would be resolved by persuasion and compromise in a well-functioning Congress. Without that, however, the executive branch lawmaking will continue to swing back and forth with presidential elections. So part two, Congress. What about Congress? Unfortunately, I can be very brief on that topic. If the executive branch is making the laws by regulation, and the executive branch is not going to exhibit self-restraint, and in fact over time is pushing limits, can't Congress fix this? In theory, it could. But the reality is, with regard to the regulatory process at least, Congress has taken almost no substantive measures since the passage of the Administrative Procedure Act in 1946. The need for congressional action may be greater than ever, but the people in this room don't need me to explain why Congress is not likely to provide us with solutions very soon. I'd like to be wrong about that. So part three, the judiciary. Assuming that Congress doesn't act, let's go to the judiciary in Article 3 of the Constitution. I'll start with the litigants who bring the cases. If we have these problems which have no ready legislative solution, and we can't assume that stability will be accomplished through executive branch self-oversight, there will still be a need to have these problems addressed somewhere. They need an outlet, and that builds pressure to litigate more often. Now, many private businesses might prefer not to litigate, right? They'd much prefer to be heard by the government. They'd much prefer to be in a situation where their needs and concerns can be addressed, even if they don't necessarily like every aspect of an outcome, so long as they think it is something they can reasonably deal with. But as the regulatory pendulum's amplitude increases to extremes, many private sector parties find themselves in this tension where they don't want to be adverse to the regulators or the government generally, but they're between a rock and a hard place. Rules swing further in one direction than the other. Rules create new demands. They create inconsistent directions. They create demands that are extraordinarily hard to meet and expectations that seem to have only short-term impact. Unfortunately, the swinging pendulum emulates the polarization of our politics. But for people seeking rationality, it may leave few options except to seek help in the courts. And that, at last, takes me to the courts themselves. Many judges in general might also prefer not to address these issues. They look like policy judgments, which they think of as the role of the elected branches. But courts do recognize the need to ensure that the law is followed and that agency actions are not arbitrary or capricious. It's not a trivial task. So how can courts address the regulatory pendulum problem? Addressing issues of administrative law is one way. Consider the issue of courts giving agencies Chevron deference. During at least the last 40 years, courts have given deference to agencies, including to these back and forth swings of the pendulum, as set out in Supreme Court cases like Fox versus the FCC, which involved changed rules on broadcast indecency, and NTCA versus Brand X, involving how the FCC classifies internet services. Back at the time of Chevron, there was thinking that deference to executive branch expertise would provide consistency and stability from the experts. But Chevron and its siblings have delivered the opposite result. They provide that executive branch reversals are fine, and they get deference. Earlier this year, in a case called Loper Bright versus Raimondo that concerns whether such deference, Chevron deference, should be revised or even done away with, Justice Kavanaugh made the point during the oral argument that, quote, when the agency changes position every 4 years, that's going to still get Chevron deference, close quote. We'll see where Loper Bright comes out. The Supreme Court hasn't ruled yet, but some have suggested that definitive judicial interpretations that are made on the basis of the laws Congress enacted and that can't be changed by each new presidential administration are more likely to be stable and predictable than rules adopted and reversed by the regulatory pendulums back and forth that are accorded deference. Now, Chevron is not the be-all, end-all, and deference is far from the only thing that matters to how courts can address regulatory issues. Both the pen and the phone and the regulatory pendulum create pressure for courts to have to address a wide range of aspects of the regulatory apparatus for making laws. The major questions doctrine, which the Supreme Court invoked in 2022 to invalidate the EPA power plant rule in the case West Virginia versus EPA, is one important aspect, but it hardly stands alone. This year alone, this term alone, the end of 2023 and 2024, we see the Supreme Court with at least 4 important cases about regulatory issues. They deal with the structure of the Consumer Financial Protection Board. They deal with the SEC's in-house courts. They deal with the timing of constitutional challenges to agencies. And they deal with Chevron deference in Loper Bright. This trend seems likely to continue. Some people will welcome more judicial review. Some people won't like it. But if the amplitude and the velocity of the pendulum swings continues to increase, the judicial role is inevitable and probably necessary. So litigation under the major questions doctrine will continue, as well as litigation about the limits of agency power, and perhaps even litigation about the non-delegation doctrine, which defines the realm where only Congress can make laws. That might be the ultimate stop to the regulatory pendulum of executive branch lawmaking. So I'll close with just one additional thought, and that is that the underlying dynamic behind the increased use of the pen and the phone and the increased regulatory pendulum is the reality of increased polarization of our politics and to some extent of our citizenry. Unfortunately, that's a much bigger issue than the regulatory process that I've addressed today. But I think if and when our political system gets back to bridging divides rather than reinforcing them, then we'll see improvements in our regulatory system to follow. In the meantime, we have to deal with the system as it is, which is what I've tried to describe today. So thank you for your interest. Thank you again to Randy and the Free State Foundation for letting me share these thoughts, and I appreciate the chance to be here.
Jeff, thank you so much. That was much more than just a few thoughts. It was an incredibly important address that I think I'm going to study over and over again. One thing I want to just mention, when I was introducing Jeff, I said that both of us were former chairs of the administrative law section of the ABA. You know, other than being president of the Free State Foundation, that's about as far as I rose, unlike Jeff. But we have here with us another former chair of the ABA administrative law section. It's rare to have three together, and that's Dick Wiley, who preceded both Jeff and I, and I'm pleased that you're here with us, Dick. You know, in my introduction this morning, or my welcome remarks this morning, I said that at the Free State Foundation, we are unabashed in our advocacy of free market-oriented principles, but also mentioned our commitment to the rule of law, which of course kind of undergirds everything that we do when we think about government. And, you know, when Jeff was speaking throughout his speech, I was thinking about how important the subject matter that you were talking about really is in terms of supporting the rule of law if we really think about what you were talking about and the problem that you were addressing, Jeff. Jeff has agreed to answer a couple of questions. The questions have to be on point, not off point. But with that warning, if anyone has a question, then we'll take it. Wait for the mic here. And you introduce if you weren't here earlier, I said, please introduce yourself before your question.
Steve Goodman with Butts Along. What you did, I guess, touch on is the Congressional Review Act, which is an ability for Congress, through sort of an expedited procedure, to veto things that agencies do. In fact, they did the privacy regulations that were part of the previous net neutrality rules. Is that any kind of a solution to some of the problems?
Only when at the turn of an administration, if one party has both the Congress and the White House. Because the difficulty with the Congressional Review Act is the president can veto those disapprovals, which happens quite a bit, actually. So the only ones that have actually passed have been at the start of a new administration, if there's a Congress of the incoming president's party, as a reach back, forgetting how far back that is, I think it's about 8 months, something like that, that you can go back and veto rules from the prior administration. But otherwise, they're both time limited, so you can't just do it on anything that's in the books. And almost never is there a 2/3 majority to do it. I don't think that's happened at all, actually, a 2/3 majority. So if the president vetoes the resolution of disapproval, you know, the rule stays in effect. But at a transition, the first few months of a new administration, if the president's party has both chambers, which did occur in both 2017 and 2021, there have been some, I think on the order of cumulative maybe 20.
Okay, do we have any other questions? Okay, if not, you know, before we thank Jeff again, I was just thinking in relation to that question when Scott Harris was here and talked about the website that calculates the days that you have to issue a government rule or whatever and help you calculate. I think the Congressional Review Act is one of the hardest darn things in the world to try and figure out, you know, the time for action or before action elapsed. So if anyone ever discovers a site that does that for the Congressional Review Act, let me know. Okay, with that, we're just once again, I want to thank the Honorable Jeffrey Rosen for giving that very important address and for being with us this morning. So join with me in that, please.